Can police officers strip search a person upon his arrival to jail after being mistakenly arrested without violating his constitutional rights? That was the question before the court in the case of the jail strip search. In this case, a defendant pled guilty to 2 lesser offenses and was sentenced to pay a fine in installments. After falling behind on his payments, the court issued an arrest warrant. The defendant subsequently paid the remainder of his fine, but the warrant was never canceled. The police mistakenly arrested the defendant under the expired warrant 2 years later and took him to jail. Once he arrived, the jail's procedures required that all incoming prisoners shower and submit to a strip search. The police checked for concealed drugs and weapons and cataloged scars, marks, and gang tattoos. The defendant sued the government for violating his civil rights, particularly his 4th Amendment right against unreasonable searches and the 14th Amendment right to due process. How would you decide the case? Can police officers strip search a person upon his arrival to jail after being mistakenly arrested without violating his constitutional rights? We'll be back in a moment to answer the question. Can police officers strip search a person upon his arrival to jail after being mistakenly arrested without violating his constitutional rights? Yes, according to the United States Supreme Court. The court decided that neither the 4th nor 14th Amendment of the U.S. Constitution prohibits strip searches of incoming inmates. Correctional officers have a substantial interest to protect prison facility staff and inmates. Although in this case the person was mistakenly arrested, there was no cause of action against the government for violation of his constitutional rights. The overriding public interest is to keep the jail staff and inmate population safe. Remember, it's a matter of law.